Okay, we are now streaming live on YouTube as well. We can get started. I guess before we do that, there are a couple folks on the call rather than watching on YouTube that I'm not recognizing. Ms. Stern, there's another Cabrera and there's a Ms. Picasso Batista. Are they with you?
Yes, Your Honor. Brianda Cabrera is Jose's sister, and then Gabriela Batista is an intern law student who's been working on this case. But if you want them to join on YouTube, that'd be fine.
Fine. I just wanted to make sure there are folks you knew were there and weren't worried about it. Every once in a while, a family member patches in and really needs to contribute mid-argument. And that gets disruptive when someone suddenly starts talking over the lawyer saying, that's not what happened. But it sounds like we've got folks who have a interest in this and they ought to stay plugged in. All right. We are now officially technologically set up. So when you're ready, Ms. Stern.
Thank you, Your Honor. Overall, our argument is that the state has failed to meet its burden that the warrantless search and seizure in this case was lawful. And then beyond the insufficiency, essentially, of the evidence, looking at each stage of the encounter with Mr. Cabrera and law enforcement, we believe that the evidence that we do have supports that at each stage, the law enforcement's actions were unlawful. And so I'll go through each stage of the encounter. Our position is that we really don't get beyond the first stage of the traffic stop. But of course, I'll present the evidence of each, or in the argument of each stage to argue why, if Your Honor does believe that the initial stage was lawful, then the next stages are not. And so I'll go into a little bit of detail there. Overall, at the time of the stop, there was not probable cause or reasonable suspicion. This is our first argument of unlawful activity. The state surprisingly chose the strategy to not present any evidence of the investigation involving the CI. I know that was kind of a hairy situation for us because we had a motion to reveal that was pending, and the state had never presented any evidence to the court or to the defense involving a CI except for just one line in the police report that said that there was a prior investigation involving a CI. I was expecting at the hearing for there to be some evidence of that, even still trying to respect the identity of the CI and make sure to not go outside of the scope of the court's orders, in order to establish that there was some other information, some other knowledge, some other information within the law enforcement's collective knowledge that led to some of their decisions and actions during the stop. But none of that evidence was presented, and the evidence for the motion to suppress was presented based on a routine traffic stop. And so for that, Your Honor, the state really is precluded from making any argument that's based on the existence of a confidential informant because they didn't put any evidence of that into the record. So we don't have any information about there being a reliable source of information, nor that the officers observed any activity that amounted to meaningful corroboration. So therefore, I'm going to focus my argument on the evidence that was presented, which was that this is a routine traffic stop.
All right, I think that's wise. I can understand fully why the state elected not to get into what may have led up to folks being interested in pulling over the car in which your client was a passenger. But the record that was made was limited to local law enforcement traffic stop. And so what would predicate the stop would have to be whatever traffic violation or other violation led to officer whomever, not the officer who testified, pulling the car over. So I agree with you, and I think we should focus from the stop forward.
Okay, thank you, Your Honor. So then at the time that the vehicle was stopped, the allegation was that there was a window tint violation. First, I'm going to focus on the insufficiency of the evidence and then the credibility of the evidence. In terms of there being evidence of a traffic violation, there wasn't any evidence presented to the court. The state didn't present Officer Witkowski, who I think was the officer who made the stop. I'm really not sure still, to be honest, from either the reports or what was presented in the evidence. I'm not sure if it was Officer Muhlenbrock or Officer Cannon, but ultimately there was a different officer who conducted the traffic stop. The only testifying witness, Canine Officer Reynolds, did not observe the traffic stop. He testified that he was not there at the time the vehicle was stopped. He wasn't watching through some sort of video surveillance. He arrived to the scene separately after Jose was already out of the vehicle. He couldn't recall how Jose got out of the vehicle. He didn't see how that took place, nor could he recall or prove when he actually arrived. So it makes it difficult for us to really assess what the circumstances of the traffic stop were. But importantly for my interest and our concern on behalf of Mr. Cabrera, in order for the state to establish that there was a valid legal basis for a traffic stop, there should have been evidence put into the record of that. There was none. The allegation through hearsay testimony was that there was a tint violation, but we did not have any evidence put into the record of what that violation was. Was there a certain percentage of legal tint darkness versus what Miss Sample's vehicle actually was? There wasn't any testimony about how dark it was or if there was difficulty seeing into the windows and to seeing the passenger. There's no evidence at all for the court's consideration of whether this truly was a valid stop for window tint. We did hear an unbiased witness testimony, Miss Sample, that she didn't have dark tint, or she didn't consider it dark, that she bought it that way without ever altering it. And she bought it from the dealer, albeit it was a used car at the time. But from at least our perspective, we presented some evidence of what the circumstances were of the window tint. And our position is that the evidence that the state presented was not sufficient to overcome their burden to prove that this was a legal, valid stop. The state has claimed for years, Your Honor, that there were no videos, no audios, nobody wore working dash cameras. There was only one limited CAD report that existed. Then magically, after the evidence closed in the motion to suppress hearing, the state turned over dash cam footage and CAD reports related to the stop. That would have been useful evidence for the court's consideration of whether this was a valid stop or not. So our position, Your Honor, is that at the time of the stop, there was not reasonable suspicion or probable cause to pull the vehicle over. The state hasn't established that there was a valid or credible traffic infraction. We think the analysis should stop there. But of course, moving beyond that, if Your Honor did find that that was a valid stop, then at that point, there was a seizure and confinement of Jose from the car that was based on nothing more than an alleged traffic violation. And therefore, his detention exceeded the scope of this traffic violation stop. At the time police arrive, they go to the passenger side of the vehicle and they open the door and tell Jose to step out. And this is coming from our unbiased witness, Ms. Sample's testimony, because the state's witness wasn't there when this happened. So the state has presented no evidence of what really took place prior to the canine search. The state claims through hearsay testimony that Officer Witkowski, Muhlenbrock, Detective Cannon, I'm not sure, smelled the odor of marijuana emanating from the vehicle at the time of the initial approach to the vehicle. However, the state didn't present any witness or testimony with that personal knowledge. In addition to insufficient evidence of these factors, it's also just not credible, Your Honor. The state claims through this hearsay testimony that Jose's window was down when the officer approached the back passenger side of the car and smelled marijuana. But the evidence in the record, which comes from both Officer Raynell's and Miss Sample's testimony, supported that there are rainy weather conditions, and the vehicle driver, Miss Sample, testified that the windows were all up at the time of the stop. It was raining. So, through this hearsay testimony, we're to believe that the window was down when the police approached the car, and therefore the police smelled marijuana, and then, that conveniently gives enough reason to pull Mr. Cabrera out of the vehicle. But we should also look, Your Honor, at what took place in the totality of the circumstances to determine whether that is a credible claim. Jose wasn't arrested with any marijuana on his person, nor was any marijuana in the vehicle. Jose had been in Miss Sample's Uber vehicle for only 4 minutes before it was stopped. And we did present and admit Exhibit D1 that showed the map of how long he was truly in the vehicle. Miss Sample, again, an unbiased witness, testified that she smelled nothing odd, no marijuana smell on Jose. And, when asked how would she know that, she said she doesn't smoke at all and she's sensitive to it, she would have noticed. There was no probable cause established to support the officer's seizure of Jose from the vehicle, because at that time it became a seizure. Let me just pull up the case.
And remind me why you think it was a seizure. Did someone testify that Mr. Cabrera could not have walked away and left the scene? And I get it that and poor Ms. Hall's going to have to navigate this. The only witness we heard from was Reynolds, who showed up after the fact for several critical junctures. Why was the car stopped? Why was Mr. Cabrera outside the car? My recollection is, but you'll correct it if I'm mistaken, was that Reynolds didn't think Mr. Cabrera was handcuffed. I don't think he was positive, but he didn't think Mr. Cabrera was handcuffed. He just was outside the car. So setting aside, was it a seizure of sorts to get Mr. Cabrera out of the car? Is there evidence that he stuck around because that was his ride? Or is the evidence he stuck around because he wasn't free to leave? Or is it's unsettled because Reynolds didn't know about that? He was there to have his dog do the dog's thing.
Right. I think that's the challenge, is that we don't know what the circumstances exactly were at the time before Officer Reynolds got there. Officer Reynolds did testify that when he was there, when it got to the point of the Terry search, that he was not free to leave at that point. That was his testimony, but there was no testimony to establish what the circumstances were before that.
The Terry search, I'm sorry to interrupt, but the Terry search was after the dog alerted?
That's what Officer Raynell's testimony was. I think Ms. Sample's testimony was a little unclear on that, but that's what Officer Raynell's.
Okay.
Yes.
Got it.
We do have Ms. Sample's testimony, though, Your Honor, that she heard the vehicle door open and heard law enforcement officers say, "Step out of the car."
Mm-hmm.
And at that point, I think there was some testimony about Jose maybe saying, "Why do I need to step out?" I'm not sure, 100% sure about that. But that then, he did step out of the vehicle. Police were around the vehicle, and I don't think it's a reasonable person would have believed that he was free to go. But in terms of the seizure, case law supports that once there is some sort of submission to the assertion of authority, that becomes a seizure. And that's State v. Walker, 295, Georgia 888, a 2014 case. This is all in the brief, Your Honor. And so at that moment, if Jose, for example, had decided to run away or walk away or something like that, then it may not have been a seizure. But because Jose submitted to the officer's submission of authority, at that point, it was a seizure, and that's also supported by Chambers v. State, Georgia App 2019. So law enforcement officers seized Jose with, at that point, nothing more than an alleged tint violation for the driver, of which Jose was not part of that investigation. He was not a party to an investigation of a tint violation. And so here we get into the argument of that his detention exceeded the scope of the stop. There was insufficient evidence of this odor of marijuana, as I mentioned before, Your Honor. Let me just see, I just lost my place. If I could have a minute. Oh, here we go. Ms. Sample testified that she was never asked for consent to search the vehicle, nor did she ever hear anyone mention marijuana or smell of marijuana. She stated that the officers opened the rear passenger door and ordered Jose to step outside. He complied with the officer's order, and Braynell's testimony supported that, at least at the point that he was there, Jose appeared cool, calm, and collected. And that was also Ms. Sample's testimony, that when he got into the vehicle, that was his demeanor as well. So the scope of the stop at this point was exceeded and prolonged. Your Honor engaged in some questions with Ms. Sample to try to get some clarity on the order of events. And there were a lot of before and after questions, if Your Honor remembered. You'd ask, did this happen before or after? And she was clear that the drug dog search occurred after she already had her license back, and potentially already had the warning. She wasn't sure about when she got the written warning, but at that point, Your Honor, the investigation for this traffic violation was over, and they maintained both the driver and the passenger there in order to continue and prolong the stop and to try to turn it into a drug investigation. Just check on something. I want to cite a case there. I think Migliori is the case on point for this, Your Honor. That's 240 Georgia App 783. An officer who questions and detains a suspect for other reasons exceeds the scope of permissible investigation unless he has reasonable suspicion of other criminal activity. The officer stopped the defendant for a traffic violation. He produced a reasonable explanation, and the officer concluded verification that the defendant's license was valid. And then rather than ticket or release him, the officer kept him there, deciding to search for drugs. And ultimately, after a drug dog search, there were drugs found, but the court remanded that for suppression. Looking to the canine search, Your Honor, it's a little difficult for me to argue on the facts of reliability for the search because we weren't able to fully explore the training and the reliability of the dog. What we did hear is that the dog Django was retired for medical reasons, but didn't provide any further details or records to support the training or reliability. A drug dog, a canine, Your Honor, is a law enforcement agent, and we do need to have the opportunity through discovery and full exploration of cross-examination to determine the training and reliability of this officer. What we heard from Officer Ray Nels was that the training records were kept at his house. He didn't bring them with him. The state didn't present any evidence of his training to support the reliability of an alert. The records are at a house of an officer. If he was still reliable or capable of doing his job, the question that I have is, why was he retired from service for medical reasons? This wasn't something I was really permitted to explore more during the hearing. But Ms. Sample did testify that she was still in the vehicle when the dog sniffed the door frame with the door open, which I found was odd because Officer Raynell said, and he confirmed, that the SOPs require that all passengers are out of the vehicle
Right. So Ms. Sample's testimony didn't line up in some ways about her timeline because things were happening before and then after, and she's in the car when the canine, no, I got all my stuff back before the canine, but I got out of the car and they didn't give me my stuff back till I was out of the car. So
Yeah.
I think your most powerful arguments are what happened before the canine search. I think once that dog alerted, things get very problematic for Mr. Cabrera on the suppression front. And so I'll hear you out on that, but I think, no pun intended, you're barking up the wrong tree saying, why was the dog medically retired? And focusing on that. You're entitled to it if you get it before a trial, if there is a trial. But I think the state has a lot of persuasive arguing to do and case citing on the stop and getting Mr. Cabrera out of the car based on the record we've got. And that's your point you're making. It's, Judge, it may well have been that there was ample PC for the stop because the windows of the car were opaque. But we don't know that. For all we know, there was no tint on the car. There's Ms. Sample saying, I bought it from a dealership, but it was used. End of discussion, end of fact pattern. You can keep going with the dog, but once a dog alerts, I think Georgia case law is pretty clear that provides some PC for the law enforcement officers there to go further. And if you want to pivot to, well, wait a minute, why were they patting my client down? We can go there. But I think it's more so, do we even ever get to wondering about the canine alert because of the procedural hurdles you've noticed that the state has in terms of supporting the stop and getting Mr. Cabrera out of the car?
Understood, Your Honor. Your microphone got a little muffled when you started talking this time. I heard most of what you said. I just wanted to bring it to your attention.
Okay, I'll try to talk louder.
No, I think it seemed like it was being covered by something, but it sounds better this time.
Okay.
Thank you. So yes, I agree with that, Your Honor, and that is largely our argument. I will just lastly say that again, this case is challenging in a lot of ways, but in one of those ways, the canine officer is aware of details in his mind from talking to other officers, and he's aware that there was some other investigation going on. This wasn't a scenario where it's, completely blind dog sniff, where an officer is just called to the scene and he's following, training and principles, and it's a reliable dog and the dog happens to alert. We don't have evidence of the reliability of the dog, but we also are aware that.
Well, we do. I mean, we have Reynolds' testimony. You may choose not to credit it. I may choose to credit it, but he testified as to the reliability. We've got all sorts of evidence about the dog and what the dog did, and no contrary evidence. Ms. Samples didn't say the dog didn't alert. Ms. Samples didn't say it looked like an unreliable dog. Obviously, that wasn't Ms. Samples' role. I'm not saying that you should have elicited that from her. But like I said, once the dog is doing its thing, I think your argument gets much more complicated about PC being developed for law enforcement to then search more in the car or be more interested in either Ms. Samples or Mr. Cabrera based on the alert. But I don't think it is accurate to say there's no evidence because you didn't get your hands on training records, or you weren't permitted to find out what medical condition caused the dog to be retired long after the dog had this alert. Those were the rulings I made, and I stand by them. But the record, unlike the basis for the stop or the reason for getting Mr. Cabrera out of the car, there is evidence in the record that would support a finding that the dog was reliable and that the dog did alert, I think twice. And more importantly, there's nothing in the record suggesting that that's not what happened.
And I'll move on, Your Honor, but I just want to correct that there is evidence in the record that Ms. Sample does not recall ever seeing the dog sit at the passenger side nor jump in her vehicle. And so there is some evidence in the record of, contradicting what the officer said. And the officer, compared to Ms. Sample, is not completely unbiased. He's aware of this background investigation, and the reliability of the dog is only as good as the handlers, of course, but I'll move on, Your Honor.
Good choice.
Thank you. So the Terry stop, or the search rather, once the dog allegedly alerts, then Officer Raynells goes over to Jose, where he's standing in front of a gas station store. During the day, there's people coming in and out of the store. And the officer approaches Jose and asks for consent to search. He denies consent, and there was some sort of questioning. Officer Raynells didn't really remember even what he asked him specifically, but at some point there's an alleged statement that Mr. Cabrera says that he smoked weed earlier in the day, in order to, I guess, support the officer's contention that they smelled marijuana from him. That was Officer Raynells' testimony. Officers can stop to question based on reasonable suspicion, but this went beyond a Terry stop. It escalated to a search and seizure with neither consent nor PC to search him at that time. They asked him for consent to search. If they believed that they had probable cause up to that point, they wouldn't have needed to do that. They asked him for consent to search. Jose denied consent, and they searched anyway. Officer Raynells testified that he patted Jose down without his consent, and that he didn't believe that he was armed. He clearly said, "No, I do not believe that he was armed, but I believe that he had contraband." Well, he believed that he had contraband based on a lot of factors that weren't presented in evidence.
But you don't know that. You need to not speculate as to what, I mean, it wasn't presented, so you don't know what Raynells knew or didn't know.
Sure, okay, yes, that's correct. Raynells did claim that he could smell marijuana on Jose, but that, in our position, is not credible. Jose was standing in a public place with people walking in and out, and also no marijuana was ultimately found on him. In terms of the statement, the alleged statement, this was a post-detention statement. Officer Raynells stated that Jose was not free to go. And so it was required at that moment or at some point before then for Jose to understand his Miranda rights. There's no evidence that he was Mirandized. And so, that statement that he smoked weed earlier should be suppressed along with the other evidence, and shouldn't factor into the determination as to whether the actions of law enforcement were proper, because it was improperly elicited in the first place. So that, that statement should not factor into whether, into the probable cause consideration for the search. The plain field doctrine also doesn't seem to apply here, Your Honor, because Officer Raynells didn't provide sufficient testimony that he immediately recognized the object in Jose's pocket as contraband. The state didn't present any testimony of Officer Raynells' experience and training with narcotics. There wasn't that exchange typically that you see and hear about how are you familiar with drugs? How many drug arrests have you made? How do you know that this felt like contraband or drugs? There was no support for the ability to immediately identify an unknown substance as contraband. And so overall, Your Honor, before the search that resulted in seizure of cocaine, there was insufficient evidence or insufficient probable cause. An arrest wasn't possible until after the cocaine was seized, and therefore the search was illegal. And essentially that's our argument, and I'm happy to fill in the blanks or provide legal support. But actually there's one case I just want to highlight because I know I sent the brief pretty late. I think it's very similar to our case, Your Honor. It's McSwain v. State, 240 Georgia Ave. 60. In that case, there was an officer who conducted a traffic stop on a vehicle that matched a description of a Georgia State Patrol radio that called for a lookout of a particular vehicle with 4 Black males who are likely to possess some sort of contraband. And that's essentially all the officer knew at the time of the traffic stop. And so he conducted the traffic stop. He didn't say there was a window tint violation. He just made the traffic stop to do the investigation. And there were some factors that, may have led an officer to have reasonable suspicion, but the court found that there wasn't. The men acted nervously. They smelled like burnt marijuana and had red eyes. They supposedly gave consent to search, and then a drug dog arrived to conduct the search. And marijuana was actually found, and so was some cocaine. But ultimately, the court reversed the denial of the suppression because the state failed to present sufficient evidence that the police had reasonable suspicion for the stop. Basically, the issue with this case is similar to the challenge that we're having, because only the officer, Kicklighter is his name, who conducted the traffic stop, testified. The state didn't call the other officers who were aware of the investigation or gave rise to this lookout call. And so there was no record at all of what the underlying reasonable suspicion was or underlying evidence was. And so the court found that, the state was required to come forward at the suppression hearing with evidence that some other law enforcement officer or officers might have reasonably relied on that, possess articulable facts and suspicion to justify the stop. But to survive a Fourth Amendment challenge, the state had to present some evidence of the factual basis for that lookout. And because the testifying officer was unable to provide the evidence, it was incumbent on the state to produce it as in some other creditable source. And so I think that's the crux of our argument, Your Honor, and I'll pass it.
Okay, I read that in your brief, and I think the McSwain case is a very creative analogy. It procedurally is sort of one step earlier. The state did have the officer who made the stop testify, but the parallel to this case is that officer was missing a piece to justify the stop. And here we were one step further along. The officer who testified didn't make the stop. It had already occurred, but we didn't hear from folks who would have provided the basis for the stop. And I think that's a strong parallel with McSwain. So I will read McSwain beyond the excerpt that was in your brief, and certainly consider that as I'm working through the arguments. So I'm going to hear from Ms. Hall now. Ms. Stern, as the movement, I'll give you a chance to have a final rebuttal if there's anything you want to say in response to what Ms. Hall shares. But I appreciate the work you've done on this and the arguments that you've made. Ms. Hall, good morning to you. Why don't you let me know what you think? And you're welcome to keep the mask on. We're far enough away and this place is empty enough that if you want to, while you're speaking, take it off. That's fine. Your decision.
Thank you, Your Honor. Your Honor, I just want to start by saying that the state's contention is that the stop was a legal stop. You heard testimony from Officer Rennells that he had knowledge from Officer Cannon, who was the initial officer who stopped the vehicle for the window tint violation, as well as in a screw tag.
Say that again.
Couldn't see the tag.
Oh, right.
It was actually two violations, and Officer Rennells had knowledge of that when he arrived at the scene. That was something that was told to him before he arrived. But to the point that Ms. Stern made, that the driver, Officer Rennells had no knowledge of the defendant being in or out of the vehicle when he got there. When he got there, he testified that the defendant was still in the vehicle, and that he rolled up the window when he heard him and Officer Snow talking about smelling marijuana in the inside of the car. So the only thing that had happened before Officer Rennells arrived on the scene was that the car was pulled over for a traffic violation. But to the point of the traffic stop being valid, there was two violations that would have given officers probable cause to stop the vehicle. Once Officer Cannon, which Officer Rennells testified to, once he approached that vehicle, they could smell the odor of marijuana, which they made known to the occupants of the vehicle. At which point, Officer Rennells testified that he was the one he had Django, which was his canine dog, go around the exterior of the vehicle, or I think he specifically testified that he went around one side in the front or the back of the back of the vehicle. But then I'm sorry, I skipped a step. The testimony was that they had both passengers get out of the vehicle. And I know that the driver testified to something different, that she was inside of the vehicle, but the state is still relying on an officer who knows that he can't have his dog inside of that vehicle with another person in the vehicle because that breaks policy. So both passengers were out of the vehicle when the dog alerted to the passenger side of that vehicle where they could smell marijuana. The search of the vehicle happened before the search of the defendant. There was no contraband, as Officer Reynolds testified to. There was no contraband found inside of the vehicle at the time of the search. When the officers, including Reynolds, who was on the scene, who talked to the defendant, approached the defendant, they could still smell the odor of marijuana, at which point he testified that he asked the defendant about the marijuana. He said he could smell the odor of marijuana still. The defendant replied, Officer Reynolds could not remember if he asked him the question or if he just responded in him saying he could smell marijuana, but that he did testify that the defendant said that he smoked earlier in the day. At that point, he admitted to a crime. At that point, the officer could have arrested him at that moment before even touching or patting him down. But beyond that, he did ask for his consent, which was declined. Officer Reynolds still patted the defendant down, at which point, he testified that he found a baseball-sized amount of cocaine inside of his jacket pocket. At which point the defendant was placed under arrest and put in one of the officer's vehicles. The state would like to rely, Your Honor, on Tusk versus State. That's 236 Georgia App 77, which says a law enforcement officer, or which concluded a law enforcement officer for his own protection and safety may conduct a pat down to find weapons that he reasonably believes or suspects is on a suspect. In this particular case, Tusk versus the state, in that case, the defendant was pulled over. He was the driver. He was pulled over. The officer could smell the odor of marijuana coming from the car, but he could also see a bulge in the defendant's pants.
Did Reynolds, though, Ms. Stern said, and I don't remember differently from what she said, that Reynolds said, I didn't think Cabrera had a weapon. When I patted him down, it wasn't for safety in that sense. It was, I didn't make sure. He said he smoked marijuana. I smelled marijuana. And so I need to make sure he didn't have anything like that on him. Am I misremembering, or my faulty memory was skewed by Ms. Stern saying Reynolds said he didn't think the guy was going to have a weapon? Because if that's the testimony, then Tusk, whatever that case is, that doesn't help, because It says, and I agree that's the state of the law, if an officer has articulable suspicion that the person he's interacting with could pose harm to him, i.e. has a weapon because he sees a bulge or this or that, then the pat down's okay. But Ms. Stern was careful to observe that Reynolds had said, this wasn't a weapon situation, this was a drug situation.
That's correct, Your Honor. Now, if you remember, during our 2 or 3 hour motion, a lot of things got muddled because I had a colleague that was also asking questions.
You did.
And what I remember is that my colleague specifically asked Officer Reynolds, if he patted the defendant down for safety reasons, because that was something she wanted me to ask, and I couldn't quite ask it the way she wanted me to. So I remember for that reason only. I could be wrong. I stand corrected, but that is my memory on that. But that's not my the case. I don't have to rely on that case completely, because at this point in this in this moment of the stop, Officer Reynolds was focused on the drugs. Now we all know that drugs could come along with weapons, but he did testify that he smelled marijuana. He was in that point investigating the smell of marijuana and where it was coming from. But if you reviewing the motion, if that you remember hearing that, or if you go back and hear that,
I'll need to look at the transcript.
Right.
I don't recall, but Ms. Stern recalled it away, and I didn't recall differently from what she said. I just knew that he had patted down and found a baseball-sized thing of drugs.
Yes. Well, just to end on that case, Your Honor, in that case, the court concluded that there was probable cause that the defendant could be arrested because of he was being suspicious he was being nervous in the vehicle, the bulge in his pocket, the smell of marijuana, which is the same in our case. Even though the officer Rennell didn't testify that the defendant was being nervous, I would argue that rolling up a window during the time in which officers are saying they smell marijuana is equivalent or almost equivalent to being nervous. So him rolling up the window, they did observe a bulge in his pocket, although they didn't say exactly what that bulge was or could identify what that bulge was. They were able to see that bulge, and I would contend that our case is on point with this if Your Honor reviews the transcript or remembers that the officer stated that he did pat him down as a course of his job in safety concerns for the officers. But moving on to another case, Your Honor, that the state will rely on is Caffey versus State, which is Caffey versus State 303 Georgia 557. In this case, the officers also had probable cause for a search of defendant's shirt pocket, which was authorized due to search incident to arrest. Now, in this case, the search incident, the search and retrieval of the contraband happened before the defendant was arrested, but the courts found in this case that sometimes that is enough probable cause. In this particular case, the defendant was pulled over. The odor of marijuana was smelled in the vehicle. The officer checked the vehicle, and there was 2 empty containers of jars that had the smell of marijuana in it, but the smell of marijuana in the vehicle left while he was searching the vehicle. When he went over to the defendant, he could still smell marijuana coming from his person. The court concluded at that moment, because the officer reasonably believed that if he searched the defendant, he would find contraband, that was enough to arrest the defendant.
So in the case you're citing, the officer hadn't formally arrested the defendant yet, but was able to effectively perform a search incident to arrest because there was sufficient probable cause to arrest at that time.
Yes, Your Honor.
I need to read that case because that fact pattern would parallel, assuming you get past the stop of the car, et cetera, that would parallel this because Django had already alerted maybe twice to the car, but they couldn't find anything. And then there's the defendant smelling like marijuana, according to law enforcement testimony. Okay, I'll have to read that case.
One moment, Your Honor. Did you get the citation, Your Honor?
303 Georgia 557.
Yes.
Yeah.
I was just reading exactly what it said, and it said to have probable cause to arrest, additional factors must be present to show a particular person is the source of the odor, and that is the arresting officer must have probable cause to believe that a particular person smells of marijuana and is in possession of it, and that is what Officer Rennell believed at the time. Although we know he did not find marijuana on his person, as Ms. Stearns refreshed our memory, and we remember from Officer Rennell's testifying, the defendant admitted to smoking the marijuana early in the day. And I have another case that supports the state's contention that the officers had probable cause to arrest the defendant when he admitted to smoking marijuana outside of the vehicle when talking to the officers. That's State v. Hammond, 313 Georgia App 882. And that says worldwide. I'm sorry.
What's the name of that case?
The name of the case is State versus Hammond, Hammond, 313 Georgia App 882. And that case says, Your Honor, that roadside questioning at a routine traffic stop does not constitute a custodial situation. Police officers at the scene of a traffic stop may conduct a general on-scene investigation which may even require that the person be temporarily detained without being classified as a custodial investigation. In this case, Your Honor, you know from the testimony that The officers smelled marijuana. They had both occupants get out of the vehicle. And at that point, they were trying to investigate to figure out where the smell of marijuana came from. They asked the driver about it. Then they went and asked the defendant about it, which they could still smell marijuana coming from his person. When he said that he smoked marijuana earlier in the day during that initial investigation, he could have been arrested. Search incident to arrest, they would have found the 86 grams of cocaine in his pocket. And then the last case that the state will rely on is Williams versus State. That's sorry. That citation is that is on 293 Georgia App 842. And in that case, a defendant was pulled over for a window tint violation, and officers could smell the odor of marijuana. They also could see a bulge in the defendant's pants pocket as well. That case says the officers are entitled to a warrantless arrest if at the time of the arrest he had probable cause to believe that the defendant was either committing or had committed an offense. And we'll rely on that for once the defendant was outside of the vehicle. The defendant doesn't have, there's no real strong argument as to him getting out of the vehicle. Once the officers smelled marijuana inside of the vehicle, Your Honor, they, in the course of their duties, they can have all passengers removed from the vehicle to check the vehicle. That was the driver's car. He was simply a passenger. If they had found the marijuana in the front driver's seat, Mr. Cabrera would have been let go or could have called another Uber or a Lyft. But because the marijuana was coming from his person, they questioned him. They located it on his person, or not the marijuana, but contraband on his person. So the state will argue that there was as far as the statement that was given by the defendant, there was no Miranda was not it was not subject to Miranda because it was during the initial investigation from the officers. And that going back to the stop, I skipped over that because I don't think the state believes that it was a valid stop. Although we did not have Officer Cannon come in and testify, that Officer Reynolds can testify on his knowledge as to what happened, although he was not there for the actual stop. He was alerted that there was a traffic stop. He didn't need anything other than knowing that if someone is requesting him to come out to run his dog, they could have ran the dog and no alert could have happened, and he would have simply left.
Okay, and I follow you on Reynolds showing up because he's requested. He's just doing what someone requested, and that someone says, "Hey, window tint, obscured tag, pull the car over. Could you just quickly run the dog around?" And it sounds like in this case we don't have the scenario of Mr. Cabrera and Ms. Samples having to wait for 3 hours for the dog to arrive. There's a whole line of cases about what's a reasonable delay in getting the canine unit there. Ms. Stern got Officer Reynolds to testify, like, yeah, we might have been really, really close. And boom, we were on scene like that. Which actually fits with his testimony of Mr. Cabrera was still in the car when I got there, as opposed to it took 40 minutes because I was on the other side of Sandy Springs or whatever town this was in. But the only thing we know about the basis for the stop in this case is Reynolds saying, someone else told me the car was stopped for these things. Is that enough, or does the state need to produce evidence that someone had an articulable suspicion, a reasonable belief, whatever the standard is, that the windows were too heavily tinted and or the tag was obscured? Because Reynolds, I don't believe, testified, yeah, I looked at the tint, that was super dark. Or I too noticed that the tag had this thing hanging over it. It was one of these, they wanted to have a camera that shows when you're backing up. And so it was installed afterwards and it couldn't see the numbers on the tag. I don't recall Reynolds testifying about that at all. So we are left with his, he may have said it more than once, but effectively his statement of someone else told me bad tint and obscured tag. And so that gets him to the scene. But does that get you, the state, past the hurdle you have to clear in terms of the propriety of the stop? The very first question that needs to be answered based on the challenge that Ms. Stern has brought.
Right, Your Honor. I apologize for skipping over that. So you heard testimony that day from the driver of that vehicle who said she was told that she was being stopped for the window violation. And then we went into her receiving a warning, a written citation, I'm sorry, not a citation, a written warning that the windows were illegal. And I think even on that warning, it actually talks about the tag as well. I can't remember if we put it into evidence, but I do remember us all, it being talked about during the time in which the evidence was open. So I think that that is valid enough to show that our stop was valid. The driver of that vehicle, Mr. Kabar, was not given any kind of citation. He had nothing to do with the stop of that vehicle. That was given to the owner of the vehicle with both violations written on it. And Mr. Kabar's issue with this situation or the stop of the vehicle came after they approached the vehicle and could smell marijuana.
Okay.
So we ask, Your Honor, based on everything that you heard in the cases that support our evidence, that you deny the motions from the defense of the statements that the defendant made and the search of the defendant.
Okay. Thank you.
You're welcome.
Ms. Stern, you can address what you would like. I'd like you to start, please, with your, I know what your answer is going to be in terms of, I know I don't agree, but I'd like you to flesh it out. So Ms. Hall points to Raynell's testimony that Cannon told him, yeah, we pulled this car over, bad tint, obscured tag. And then Ms. Samples talked about having received a warning for bad tint and obscured tag, and having been told by some officer that that was the basis for the stop. So that's the totality of the evidence that the state points to, and I think that they can point to. Why is that not enough?
It's not enough because in our country, in our justice system, just an officer saying something took place, it doesn't necessarily mean that it's true, or just by a citation being written doesn't necessarily mean that it's true. I mean, there's other factors involved. We know that there was this other investigation involved that was truly the basis for the stop. And, you know, there are pretextual reasons why an officer may pull over a vehicle, but they still have to establish it at an evidentiary hearing to make sure that it in fact occurred, and that it not just that a citation was written, but that there was an actual violation of the law.
But what would that be? I mean, let's say the officer had stopped the car because it failed to signal before making a turn, and Cannon tells Raynell's, hey, you got to come down. I pulled this car over because it failed to signal, and I'd just like you to have the dog walk around it. If you can be here in less than 5 minutes, that'll work. We won't be holding these people too long. He didn't testify. It was Raynell's who testified. And then Ms. Sample said, yeah, I got pulled over because the officer said I forgot to signal, and you know what, I may have, I don't know, just like if my windows are tinted, I don't know if they're too tinted. Why is that not enough? And what more ought there to be in that situation?
Well, using that example, let's just say that Ms. Sample failed to turn on her turn signal, and that was the basis for the traffic stop. We have a witness that the defense is putting forward to establish contradictory evidence. I did put my turn signal on. You know, my windows weren't too tinted. I don't believe that I actually violated the law. And there was no evidence presented by the state when it's, you know, their burden to establish that there was not a Fourth Amendment violation. And, you know, the expectation is just whatever, you know, a police officer writes in a citation should be sufficient. That's why there's dash cam video these days. That's why there's the opportunity to cross-examine and ask questions. Maybe there's an issue with the road, or maybe there's an issue with the vehicle, or, you know, I guess moving towards the example of the window tint, because that's what we had here. It could be that it really truly didn't violate the law.
Well, and she didn't get a ticket. In the end, there wasn't, no one is asserting that it did, but I guess I'm just trying to understand. Let's say Cannon did testify, and he said, "Yep, the windows look pretty dark to me, and the tag looked obscured." And I pulled her over, and she gave me her spiel about, "Well, I bought it from a dealership, but it's used." And I gave her a warning because I give people warnings sometimes. She wasn't going 90 in a 30-mile-per-hour school zone. It wasn't a DUI. So I gave her a warning. Hopefully her tag won't be obscured next time. What did that testimony add to the record we already have?
It's the testimony. It's also the evidence being in the record to be able to prepare adequately for a defense. So there was nothing in the police report at all about there being an obscured tag. So there wasn't an opportunity for us to properly investigate that. I didn't have a chance to cross-examine the officer on that as to why didn't he include that in his report, or what was obscure about it, what were you not able to see, all the things that typically we'd be able to engage in line of questioning about. I didn't get to ask the officer about whether he was having a hard time seeing the driver, or why was that a violation, or why did he think it was a violation of the law. The state essentially is taking the position that they don't have to prove those things, and that it should just be enough for one officer who was involved in a few different steps later to be there. It's about being able to properly prepare and inquire to establish whether there truly was a violation or not. Miss Sample didn't have the vehicle anymore, so we couldn't go take the vehicle to get it tested, or to try to establish our own evidence, although it's not our burden, it's the state's. And there were
no, it's not your burden, but to your point, and as you demonstrated quite ably by having Ms. Samples come all the way from Nevada, you can present evidence. Is there a reason why you didn't call Officer Cannon so that you could engage in that cross-examination to attempt to show what you contend was a pretextual stop? Not saying you had a burden to do any of that, but you certainly weren't prohibited from trying to make this record that you're suggesting exists, that this was all a pretext based on the CI, et cetera. But that's your theory. There's no evidence of that.
It's not my burden, but I also honestly didn't know who the officer was. I really didn't know, out of all the officers that were there, who was the officer that really made this stop. The reports weren't clear. The officer who testified wasn't, clear exactly who was in the same vehicle, which officer was responsible for what. And so essentially it's the state's burden to prove that. And it's an important stage, especially when the investigation, the case is based on something that they have not presented any evidence about. And now the state really kind of wants to have it both ways. They don't want to present any evidence about it, but then they also want to rely on a lack of evidence in support of the motion to suppress. And it's creating challenges at this point. Moving beyond that, Your Honor, I'll kind of work, working towards the search. When Officer Reynolds arrived, it may have been that he did arrive while Jose was still in the vehicle. I may have gotten that wrong there, but I am very adamant in remembering that Officer Reynolds was not able to remember how Jose was removed from the car. So even if Jose was still in the vehicle when he got there, he couldn't testify to the circumstances surrounding getting out of the car. And I don't believe he testified to smelling marijuana himself at the car point before Jose was removed from the vehicle. I think it's an important step that we're not necessarily focusing too much on, that the exceeding the scope of the traffic stop is a major issue in this case, because we weren't able to establish any time periods because of the challenges with which officers testified, the lack of the CAD reports to determine how long it did really take for Officer Reynolds to arrive. We don't know how long it took. And so I think we all were under the impression that it wasn't 40 minutes, but there was not a dialogue or any evidence in the record about how long it was or what the period of time was that Jose was waiting and Ms. Sample were waiting for the next stage of the investigation. So I do think that that's a concern.
Your Honor, may I respond to that?
Hold on one second. Pardon me?
I just want to ask if I could respond to that statement.
Okay, let Ms. Cabrera, let Ms. Stern wrap up, and then I'll hear from you on that. I'm remembering through cross-examination, and I say remember, we need to get the transcript. We all need to read it. Ms. Rivers has a project. It was through cross-examination as part of this, this was all planned. You knew this car was going to get pulled over theory from the defense, that Reynolds ultimately acknowledged actually was real near the spot. We were staged, meaning, I want to be clear what I mean by that. Reynolds was not on another call at the far end of town. He was expecting to be called to this scene and got there quickly, which is consistent with his testimony. When I got there, Mr. Cabrera was still in the car. And I think if you piece together Ms. Sample's testimony, which is repeatedly referred to as unbiased and thus extremely credible, you can put together a timeline that would suggest that your strongest argument is not going to be that it took too long for the Canine unit to get there and have the alert that it had.
Sure, it's not necessarily about the time, Your Honor. The cases that are on this issue don't really focus on the time necessarily. It focuses on the actions of the officers and what the purpose of the stop was, and then it moving to a different stage once that.
Well, I think it's both. The time certainly matters because you need to be able to justify longer and longer waits. And if there's no wait at all, because they're still processing, haven't written the citation, person's not free to go. We've got Ms. Sample saying, then I got out of the car and I'm standing over there out of the rain. I'm talking with the officers. It didn't sound like she had been processed and released before things were happening. In fact, she says, I was still in the car when the dog was walking around it. And she wasn't in the car very long. I'll review the transcript. I think you're right. It's two pieces that have to be analyzed. How long did it take? But where were we procedurally? If in 30 seconds, Cannon had said, here's your warning. And then they waited just 2 minutes. He had finished. He had given her the warning and she should have been able to leave. That's not how I'm remembering her testimony, but I will review it.
In the time frame where Ms. Sample has her license back and that part of the investigation is over, if in that time period there's prolonged questioning of Jose through the window with the window cracked open, for example, and that's where supposedly the officers are smelling marijuana, those are all things that are taking place that otherwise wouldn't have if the stop ended, when it should have, based on what the purpose of the stop was.
Sure.
Moving through that, Officer Reynolds was not able to testify to actually smelling marijuana himself at the time Jose was in the vehicle. So we don't have credible evidence of that or sufficient evidence of that. And we do have to consider the credibility, of course, too. I mean, there ultimately wasn't any marijuana found. He was in the vehicle for a very short period of time. And that's really the main difference and distinguishing factor from Caffey versus the state, Your Honor. In that case, the only reason why the police were able to get to the search upon incident of arrest exception is because there was enough probable cause prior to that point in order to justify an arrest. We don't have that here. What the probable cause was in the Caffey case was that they smelled the odor of raw marijuana coming from the vehicle. Then they had Caffey step out of the vehicle and the odor dissipated. Then when they would go towards Caffey, they would smell it. And then when they would step back away, they didn't smell it anymore.
Right.
So there was more evidence established of that. Plus, they did find 2 empty bottles of that smelled like raw marijuana in the vehicle. So all those factors were adding up to be probable cause for the fact that he was possessing marijuana. So I argue, Your Honor, that the Caffey is distinguishable based on that. I think the last point really is, it's important that the statement about that allegedly Jose made that he smoked weed earlier in the day, that we are not considering that. I don't think the court should consider that.
I understand, because you think it was interrogation after he was in custody, and there's zero evidence that he was Mirandized. So if I find that it was a custodial statement, then it's not something that ought to be used to justify any subsequent police conduct because it would have been improperly obtained.
Right. Okay. And then lastly, Your Honor, State v. Hammond, that actually was my case that I lost on appeal. And in that case, Mr. Hammond was on a bicycle. If I'm remembering correctly, it was a long time ago in 2012. And so I think the reason why that we were overturned on that was because he could just have driven away on his bicycle at any point. But that's not what we have here. So I'd argue that at different stages, Your Honor, there's a lack of reasonable suspicion that was established by the state, and for each step of the way there are concerns, and so I ask that you find that there's not probable cause for this search for the various reasons stated.
Okay. We are almost out of time before we take our plea in federal custody, but there was something, Ms. Hall, you wanted to say, something Ms. Stern said triggered something for you. What was that? Do you recall?
Yes, Your Honor. I think you pretty much touched on it when you responded. It was more so the overall. I think you were here. We all were here for this motion. The case is not as confusing as Ms. Stern would like it to be. She keeps saying she don't know this, she doesn't know that. But Officer Cannon's report was handed over. There's a simple report that says he pulled over this car and what reason he pulled over that car. So it's not confusing as to which officer did it. She could have called him, she could have whatever, but it's not confusing as to who did what in this case. And she said she don't know how long it took. We don't know how long it took for Officer Reneros to get there. Reneros said that he was parked on another street when he got the call because he was a part of this investigation. And her own witness came here and testified, not that it took him a few minutes to get there or 5-6 minutes. She said immediately. That was the word that she used. As soon as she stopped and saw the other car, he pulled up. So, like you said, there's no question, so I wasn't going to go into it, but I just don't want it to be, it's not confusing as to what happened here. Everything is, there's reports for everybody that was involved in this case. I understand that there was video that was just signed over, but as far as the reports and what was testified to, that was handed over, and that knowledge is known. So that's all I wanted to add, Your Honor.
Okay. Well, I'm going to agree with both of you. I think that Ms. Stern has had to go to, in my experience, unprecedented lengths to get basic discoverable material. I'm not faulting the district attorney's office for that. At the same time, the nuts and bolts of what happened at the gas station are not particularly profound. It's just hard to get a fully contextual sense of it because it sounds like for a while folks were pretty limited in what they had. There were some police reports, but not what typically accompanies it. And then finally, overarching all this is, of course, the knowledge that both sides have, but it's not part of this analysis, that there was a bigger investigation going on and that there are pieces of it that law enforcement and the district attorney's office or the U.S. attorney's office or wherever it may be are making a strategic decision that they're not going to rely on, and they're perfectly entitled to do that. And it may leave one hand tied behind the back for the state. That's not Mr. Cabrera's problem. It's a calculated decision that law enforcement makes that sometimes might make an otherwise simple stop in what happened much more complicated, and it may not work out well for the state. Maybe their larger goal is accomplished regardless of what happens with this. Clearly, there were a lot of drugs involved. There's no question that Mr. Cabrera was a courier, but that's not what's at issue here. What's at issue is the propriety or lack thereof of the stop at a variety of stages. And I appreciate how Ms. Stern has parsed it out. It's not just the stop, then it's getting him out of the car, and it's asking him questions, and then it's searching his person. It's different steps that occurred, and each one needs to be okay constitutionally to get to that final piece of finding the contraband on Mr. Cabrera. Ms. Rivers, we will need the transcript of the suppression hearing. That was a long one. Mr. Cabrera is on bond, so it's not a please hurry up and do it in 48 hours, but we'll need to pause until that's available. Do you have a sense of when you might be able to do that?
I started today, Judge.
No, I don't mean today's transcript. I mean the big one. You think it will be done by the end of today?
No, I will get started on it today.
Got it. Okay.
when you get started and sort of scope it out, if you could let Ms. Nelson know how much time you'd need, we can just push that information out to Ms. Hall and Ms. Stern. They'll get a copy of it when it's ready, but that'll just help them know. I'm not going to start working through this until I get the transcripts. I know you've got other things you're working on as well, but when you get a sense of a reasonable date for getting that e-filed, let Ms. Nelson know, please, and then we'll share it with everyone.
Okay, great.
All right, Ms. Stern, anything else we need to work through? We got about 5 minutes before I need to get on a WebEx with a federal detention center.
Have fun with those WebExes. Those are always interesting from RAD if it's there. On the discovery issues, could we address that briefly?
Sure.
Okay, so when we were, I think there's two different aspects of this. One is that when we were with Your Honor last time, you set certain deadlines for the state to get us certain evidence. So there's that piece of it. And then there's also the situation where, separate from the phone dump evidence after the hearing, there was new evidence that came to light after the hearing. I guess talking about the new evidence that came to light first, there were some CAD reports and video recordings. I haven't had a chance to really look at all of them since I've gotten it, so I don't necessarily know exactly what the content is, but in terms of there being certain rules for discovery and it being 3 years, how long this case has been going on, and that Your Honor didn't have the benefit of the evidence in the hearing, and nor did we. I'm asking the court to exclude the evidence from consideration of a jury if it goes that far, because it's a discovery violation, and it's created challenges for all of the parties involved. And it just seems like the state, whether it's the police involved here or the DA's office, I'm not trying to.
No, and it doesn't matter. It's the state. I mean, you're right. And we're not trying to demonize anyone, but the state equals law enforcement, DA's office, et cetera. And only now, or very recently, did you get some things that ought to have been available long ago. Here's my thought on that. It's a pretty high bar for me to properly exclude it. There has to be bad faith. There has to be prejudice. And I don't think I could reach the prejudice hurdle yet because you haven't had a chance to look at it. It may be phenomenal for you because it completely undercuts everything Rennell's testified to. And so it's beautiful impeachment evidence. So my thought is, why don't you review what you got? And then you would be in a better position to articulate how you would be prejudiced at trial. Because the other thing I have to assess per the case law, as I understand it, is, yes, you got it late, but is it too late? Our trial, if there's going to be a trial in this case, and let's get through the suppression motion first. If there's going to be a trial, it is a ways away. And so the prejudice to you, other than it may have hamstrung you in presenting what you wanted to present in the suppression hearing, and I think you would have a very strong argument to reopen the record if you wanted to get in some evidence that was exculpatory or it undercut, like I was saying, what Rennell's was saying, or supported what Ms. Samples was saying. If it's the reverse, if it is a slam dunk for the state, and it would have been awfully nice for them to have it during the suppression hearing, the sanction's been administered because they didn't have it and they couldn't use it during the suppression hearing. But insofar as it would be used at trial, I think you'll need to think a little bit about how, given that there won't be a trial for months, you are prejudiced by getting it only now. Not the suppression hearing, but the trial, because I'm pretty sure that's the test that I need to apply, is how are you prejudiced at trial if you got it 6 months before trial instead of 3 years. And you may be able to articulate it. Witnesses are gone, they don't remember, or who knows what. I would have followed up on this with this dash cam. I saw 10 different license plates. I would have like, all right, who was the driver of that car? And now I can't figure that out anymore. I'm not saying there's not a way to articulate it, but I think it's premature to simply say, I got something indisputably late,
And so it needs to be excluded because I don't think that's the test I'm supposed to apply.
Okay. I'll address that once I have a bit more understanding of what the content is. I know Your Honor has to go. Is there an opportunity just to ask about the dump, or do we need to?
Yeah, no, let's ask. I know that there was a, ask me about it or ask
Well,
the
just
state about
if there's time still for a few minutes to just address that.
it. Okay, what are you asking about? I thought you got it. Did you not get it?
So we do have, the deadline was April 12th. We received notice that it's available for pickup on April the 14th. We did pick it up. From what I was able to see is that there's data from a Samsung phone, but not data from the iPhone. So there's a folder with iPhone Celebrate files, but nothing is there. So I just wanted to confirm with the state if that means there is no evidence from the iPhone, and also just if the court is likely to keep that evidence in, even though it was beyond the deadline.
What's the answer was it a technical glitch and there is iPhone data and it just didn't make it to you, or they weren't able to extract anything from the iPhone?
There's evidence from both. She should see the evidence from the iPhone and from the Samsung.
Okay, why don't we do this? Ms. Stern, if you'd reach out to Ms. Hall as soon as you're in a position to do so, either she can help you access it, or it could be that for whatever reason, the copy you got, whether it's a DVD or a thumb drive, it just wasn't copied over. But Ms. Hall is saying that they were able to extract data from both phones, and so you should have something from both phones. I'm not inclined to exclude that any more than the other materials, the CAD reports, the dash cam, et cetera, unless and until you're in a position to say, here's why Mr. Cabrera was prejudiced by the late disclosure. That's late in a couple dimensions. One, they've had the phones for a long time, but it did also miss a deadline. My understanding was that the DA's office had to engage in some extraordinary measures to get the local law enforcement folks to do what they had been directed to do. Was it an order from the court, or was it a request from the court and they needed some clarification? So that may have delayed things a little bit. But either way, you ought to have data from two phones. If you are unable to get that from the DA's office, Ms. Stern, within, let's say, a week or so, by trying to coordinate with Ms. Hall, let Ms. Nelson know and we'll just get you on the phone, both lawyers, and figure out what the heck the issue is. In the meantime, I'm going to wait for the transcript from Ms. Rivers and focus on the suppression hearing. That ruling may make moot some of the concerns that you raised today, or it may crystallize those concerns, Ms. Stern, about the discovery that you are only recently getting. Ms. Hall, anything else before we wrap up?
John, I just wanted to say that we didn't say what the evidence was. It was the two CAD reports that we were trying to locate, and it was 4 dash cams of the incident. That was all the evidence that was turned over, and it was from all 4 officers that was on the scene.
Okay, not body cam, but dash
Not body
cam.
cam, just dash cam.
This was pre-body cam.
Well, they didn't have body cam at the time. Those particular officers didn't
Right.
have body cam, but
Okay.
yeah, so just dash cam and 2 CAD reports.
Okay. All right. Ms. Stern, anything else?
No, Your Honor, thank you very much.
All right. Thank you all.
Thank you.
Okay,
Yes, ma'am.
Judge, I think that you'll have to make me the host on this
One
in
second.
order to go to your other move.
So I'll do the WebEx.
Yes, if you go ahead and
I'll make you the
be
host. Yes, ma'am.
host on this one, we'll
Yeah.
hold this meeting open, and then we'll both go to the WebEx.
Yeah. All right. You are going to be the host. All right. There we go. So I can drop off this call and get in the WebEx.
Correct. Thank
Okay.
you.
Thanks. Yes, ma'am. Yeah. So we're taking a plea now with an inmate who's in federal custody. That's scheduled at 11. That'll take about a half. Ms. Patel, you think about a half hour for the plea? Anything complicated about it other than it's remote? Okay. And then we'll turn to Mr. Mathis. Yeah. Okay. So we are doing it, and we'll do it as quickly as we can, but I'm guessing around 11:30, we'll do that. Thanks.
Ms. Nelson, so do we leave this one and go to the WebEx and then come back to this one?
Yeah, I don't have a WebEx. Does anyone have it?
Yes, I do.
I don't have one.
I got an email from Ms. Nelson saying that Ms. Beasley was going to create one and that we should get an invite, but that was to Ms. Nelson.
Okay, I see something here now, Judge.
Where do you see it?
I see it from Miss Beasley.
It's in your email
Yes,
at 11. Yeah.
it just came this morning, so I'm gonna have to log out of this one.
Okay, can someone forward it to me? I don't have an email from Ms. Beasley.
Okay, I'll do that now.
Thank you. Oh, I got it. I'm sorry. Yeah, I got it from Ms. Nelson.
Okay.
I will join now. We'll see what happens.
Mr. Patel, how are you gonna plug in?
I have no idea.
I don't know, who's in the room with you? That's up to you guys. Mr. Patel, do you have a laptop with you?
I do not. I'm trying to think, we might have a web camera on our 5th floor office, I can check. I'm not sure if I could log into one of these computers.
Yeah, I don't know how, I mean, one option is that you could,
I could also try to use my phone and sit outside.
okay, I think these are all on, the Zoom call that we'll pivot back to take the plea, at Mr. Mathis, which I think is also yours.
Correct.
Okay, so do you have the link for this?
I did receive the email from Ms. Nelson.
Do you want to try just being in the jury room with your phone?
I can try that. Do I need software for the WebEx?
It will give it to you. If
Okay.
you just go click on the link, it goes into your browser and then it'll give you whatever you need.
We'll try that out.
All right. All right, so we are waiting, so we've got two Patels in the mix. We have Siri Patel, that's our prosecutor. Hello, Prosecutor Patel. Good morning. And then we have Shamal Patel, that's Defense Attorney Patel. She is going into the jury room here to try to get into the WebEx call through her phone. Because our computer system, other than my machine, is in a Zoom call that we can't get out of. Ms. Patel, how do we pronounce the defendant's last name? McMenamin, is that you? Yes. All right, so you're Mr. McMenamin. Great, I'm Judge McBurney, it's nice to meet you. You're in federal custody right now? All right. Once Ms. Patel, your lawyer, Ms. Patel, gets on, we'll get started. My understanding, Mr. McMenamin, is that through great efforts by Bureau of Prisons, as well as our Department of Corrections, we've established a video link with Coleman, and you are prepared to enter a plea in your Fulton County, state of Georgia case. Is that correct? Okay, well, we're gonna wait till your lawyer's on to do anything more with that, but I appreciate everyone making this a possibility because transporting folks is kind of complicated. Comes the other Ms. Patel. Yes, ma'am, and I saw you briefly, you just disappeared, but we heard you, can you hear me? Great. There you are. You ready to proceed? Sure, she was on our Zoom session? Sure, let's do that. Thanks. So what happened with that Cox case? It got re-indicted and then continued?
Well, I filed a motion to continue. He didn't sign it because the case had already been closed. But we have a date in May, and I really think it's gonna be.
It's a trial date in May?
In Odyssey, it says plea.
Oh, well, I guess someone has a
So
crystal
I
ball.
think it's just gonna be one of his more general calendars, because I think we're trying to do a pre-trial trial calendar in mid-May, so I think he's gonna end up on that one.
Okay. Well, great.
I came this morning just to make sure, because I wasn't sure if they were even gonna call the calendar anywhere.
Yeah. Well, we had, so there are only 3 positions left on that calendar. And the one that's going out, which is Judge Richardson, and then Judge Krause has one. Judge Whitaker, 1 defendant, 2 cases, so they only try 1. So one of those 2, and I think Krause is the oldest, that'll go next Monday.
That's the one with Thomas Mondelli, the murder case.
It's, yeah,
It should be interesting.
okay, well, let me get everything going here. First of all, Ms. Beasley, thank you so much for working with the Bureau of Prisons to make this happen. Ms. Rivers, are you able to see, or more importantly, hear what's going on? Great, well then we'll get started. This is case 18 SC 161678. It's State versus Timothy McMenamin. I'm Judge McBurney. Mr. McMenamin, I don't think we've ever met. You are joining this session from a federal prison, FCI Coleman. Your attorney, Shamal Patel, is also on the call. She's here in the courthouse. I think she's in jury room right next door to me right now. Mr. McMenamin, before we go any further, I need to make sure you are waiving your right to be here in open court and that you are comfortable proceeding remotely. The other thing that is a little different about this process is that your lawyer, Shamal Patel, is not sitting right next to you. Normally, that's how we do it, so that if you've got a question, she does, you can ask each other. We're not able to do that right now because you are wherever FCI Coleman is, and Ms. Patel, as mentioned, is here in the Fulton County Courthouse. Are you comfortable, Mr. McMenamin, proceeding with Ms. Patel not being in the same space as you? So that's a great question. I use WebEx very infrequently. We are Zoom raised here in Fulton County. I noticed there is, yes, please do. Great, there's your answer. Our technical expert, Ms. Beasley, has observed that we can, and so that was the last part of my spiel. I just didn't want to offer it up unless I knew we could do it. So Mr. McMenamin, if at any point you need to speak privately with Ms. Patel, let me know that, and we'll figure out what buttons to press so that you and Ms. Patel are in that breakout room. Those operate as if you two were alone in a room. We will not be able to hear or see whatever you discuss. And when you're done with that discussion, you can rejoin us. There ought not to be many surprises in this process. Hopefully you and Ms. Patel have worked through what the expectations are, but nothing is guaranteed in this line of work. So if something does come up that you want to speak about with Ms. Patel, just let me know and we'll honor that request. But I won't know unless you say, hey, we need to take a break, okay? Great. All right, Siri Patel, your turn, take it away.
Are you able to read, write, and understand English language? Do you understand that you are charged with 2 kinds of aggravated assault? Do you understand that you have the right to plead either guilty or not to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak with your lawyer, who's shown us about all the facts and circumstances to you regarding the charges at the same time that you plead to cases? And do you need more time to discuss this case with your attorney? Are you satisfied with your services? And counsel, do you waive formal reading the indictment? Do you waive any apologies that's in the indictment, including discuss the evidence? And Mr. McMenamin, were you arrested on these charges? The state's under any outstanding warrants relating to these charges, do you or your attorney know of any? And do you understand that this is a negotiated plea of guilty and the state to report a sentence of 2 years of probation to commencement of your release from federal custody for the first time since September 2022? And the court contends with the maximum money charged and the sentences consecutively for do you understand that? And do you understand this plea relates to the sentencing of other convictions in this jurisdiction as well as in other jurisdictions? And do you understand that you're Do you understand that if you are placed on probation of any kind, you can't violate any criminal laws of any government unit or any special conditions of probation without being subject to revocation for the balance of its sentence? Do you understand that you are not to possess or use a firearm while on probation? Do you understand that if you are a United States citizen, the Guilty Plea Commission will put your conviction status will result in petition just for conviction and trial, and that this is true regardless of any advice writer, attorney, or anyone else. Do you understand that you report your attorney or the district attorney's office as any conviction wrong is earned or to report or disclose, and no one can hear it wrong through the Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be a conviction following a trial? For example, guilty plea may have threats to road, threats to improvements, threats to serve on jury, threats to take a passport, threats to receive, possess, or transfer a firearm, or the ability to take a loan. Do you understand that by pleading guilty to the felony, you use, receive, possess, or transfer a firearm, or use a firearm for crime, plead guilty to the felony which may be innocent? Do you understand that you break any knowledge practice in pleading as consequences by actually pleading guilty? Do you understand that you must trial, you have a right to testify jury, or to hear, or to testify against, in order to testify or consent that they not produce? Do you understand that by pleading guilty you give up your rights, your instructional jury, right to remain silent and not remain assault, right to court witnesses against you, right to assistance in cause of your body, right to presumption of innocence, right to testify on your own behalf, and to present other evidence, right to subpoena witnesses and formal virtual evidence, right to have the charges against you and the right to appeal to the courts of the jury after trial. Does anyone force, threaten, or cause you anything to get you to enter a guilty plea? Your Honor, it is this shot as well as the shot that's actually
Yeah, we got a little orange triangle from her. Ms. Patel, are you there? We can. Ms. Nelson has suggested a fallback if this is overwhelming your phone. We can, I could log into a computer in my chambers and you could connect that way if that's easier. No, there you are. Good. Welcome to County Wi-Fi. Fantastic. You're welcome to be video off until you need to say something, just to help reduce the strain on your phone. All right.
And that's her guilty plea because of her acts guilty. And how do you plead to the charge charges of 2 counts of aggravated stalking in an indictment number 18 SC 161678. And is this guilty plea freely and voluntarily given with full knowledge of insurance? Yes. Do you understand that you have limited rights for this guilty plea conviction? Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Your Honor, the defendant's criminal history has been prior at-risk share. I know there's a prior conviction for usury and federal. That was sentenced for, unfortunately, and honestly, it's not working, so it's not full history. So I will start probation.
Sure.
As for the factual basis, the defendant had pled guilty previously, under a 2017 case, 18 SC S6901, regarding the state victim, Ms. Bragg, and was given instructions to not contact Ms. Bragg as a result of that plea. However, Ms. Bragg received 2 contacts from the defendant, one was from April to the 2018. Other who lives in Alpharetta, which is in Detention County, received a physical letter in the mail, content of which was asking her, which is contacting her. And then as of August 18th, 2018, Ms. Bragg received an email from the defendant as well. The email is from and her work email, which she stated she's going to provide. This also made a statement for the court. She said, statement is as follows. You wrote an email to me on August 18th, 2018. This is 5 months after we sentenced to 3 years for aggravated stalking. We received 3 years and continued to contact from jail after what was in place. While serving the sentence, and chose to contact me again. Your plea was received. I realized writing you decided to say what asked for information, so the police officer that was the parts of law was found again to the instance. I'm writing to you with a creativity or an desperately. Another approach is I'm going to business. She also continues to have her to be told to have speaking solutions. Last quote that she included in that email was that she was everything is the lack of better word. This says that team has never respected the law and continued to jail with its actions that travel in this terms of probation. His actions have changed the way I feel in my life and continue to live with their communities. And we state our friends that we since 2 years of probation, those 1 and 2 months of friends each other and 2 consecutive to his
And why 2 years and why probation? You shared with me Ms. Bragg's perspective, which is probation's not going to be sufficiently protective for her. What was the state's thinking about just assume the sentence in the older case, also an 18 SC case, was 3 years probation, not 3 years jail?
Yes, that's correct.
So we've got a sentence that Mr. McMenamin is not correct. Okay. Okay, so, okay. And so maybe he had a 3 years to serve sentence from whatever judge had the other case. And yet while under that sentence, which ought to drive home the point, he should not be contacting Ms. Bragg. He went ahead and did it twice, a letter that Ms. Bragg's mother received and then email to Ms. Bragg. Why would a lesser sentence be the appropriate sanction for repeating the conduct that got the jail sentence?
It's, well, it's easy to describe, she became a child from him, since that incident. Additionally, I think that's 80 years, so I just rounded it out to 60 years sentence. And also 3 years of other cases, I rounded it out to 5 total. So I just was hoping I could resolve this case in the interest of describing it over the months. Global resolution.
Okay. I appreciate that perspective. Ms. Patel, Shama Patel, do you want to talk about your client's criminal history, or should I get that from Ms. Crawford? Okay, and what's the federal case? Out of what jurisdiction? Okay, and what sentence did you get? That must have been a high dollar value healthcare fraud to get a sentence that long. Okay, were there co-defendants? I mean, you say conspiracy, there must have been other people. Of the 94 months, how many have you done? Okay. Okay. Got it. So you've got a few years left. All right. Shama Patel, tell me what you'd like to tell me about Mr. McMenamin's situation. I appreciate you sharing that. That's helpful background. So Mr. McMenamin, upon release from federal custody, hopes to live in the Chicago area. Am I following you correctly? Ms. Patel, well, you can answer, Mr. McMenamin. And what is there? How does he know that 6 years from now, 7 years from now, whatever it would be, that's someplace he can go? Okay. Okay, got it. Siri Patel, quick question for you about Ms. Bragg. I don't want you to disclose her current address other than I need to know if it's in Georgia, and if so, if it's in the northern half of the state or the southern half of the state. All right, if you can find that out, well, I have a few other questions for Mr. McMenamin and his lawyer. But let me make sure, Ms. Crawford, any active, open, probated cases from Fulton that we need to know about if we're trying to wrap up all of Mr. McMenamin's business? Got it. Good morning. Thank you. Okay. Do you know, Siri Patel or Shama Patel, how one authors a final disposition that says probation not to begin until completion of other sentence? Is that basically the language that this sentence, I guess it doesn't matter whether it's probation or it's custody. The sentence that I'm going to impose, assuming I accept Mr. McMenamin's plea, should run consecutive to the sentence in the federal case. That's basically what I ought to say. So I will need, more importantly, Ms. Nelson will need, if one of you can email it to her or text it to her, the style of the federal case. It's going to be 18 CR something, and it will need to run consecutive to that. So Ms. Nelson is telling me she knows the wording to use. She'll just need the federal case number. So if you can get that to her. Ms. Siri Patel, did Ms. Bragg want to share anything more than what you shared? I followed very closely the written statement she provided that you read. Is there anything more she wants to provide, or that's it? Okay. Mr. McMenamin, yeah, I'm gonna see if I think Shama Patel has shared everything she wants to. Is that correct? Ms. Patel? Okay, so Mr. McMenamin, it's your plea and your sentencing, so of all the folks in the mix, you have the absolute right to say something if you want to. Know that you're talking to me. Ms. Bragg is listening, but you need to address your comments to me. Okay. Only if you want to. You're not required to say anything at all, but if there's something that you want to share with me, now's the time to do it. well, tough lesson to learn the way you had to learn it, but I appreciate you sharing that. Siri Patel, the indictment lists the victim as a Lauren Bragg. That's the same as Mandy Bragg, or is that a defect? We need to make sure it's not an issue. Okay, got it. All right, well, Mr. McMillan, I find there's a factual basis for your plea. Sounds like just from the excerpts I heard from your email, you knew what you were doing was potentially going to run you afoul of the law again, because you had just been sentenced for aggravated stalking. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we talked about. You are an intelligent man. You haven't always used that intelligence in the smartest of ways, but that doesn't mean you don't understand things. So I do find your plea was knowing. Do you have any questions of me or any questions you need to ask your lawyer about anything we discussed thus far? It's not irrelevant, it's important, and what will happen is that Ms. Patel, your Ms. Patel, someone Patel, will get a copy and she can get it to you. It is not standard practice for a court to mail it to the defendant, but Ms. Patel will get a copy of what's called the final disposition, and she can get that to you. She knows how to reach you. She can put it in the mail, or if there's email, she can scan it and send it to FCI Coleman. So you're entitled to it. It will be Shama Patel's obligation to get it to you. Anything else? Okay. I also find that your plea is voluntary. That simply means no one's forced you to move forward with this plea. It's a decision you've made after consulting with your lawyer that you believe is in your best interest. Is that correct? All right. I'm going to accept your plea. I will follow the recommendation now that I better understand your situation. I don't think tacking more prison time on top of the substantial prison sentence you receive in federal court will change much. You'll do at least 85% of that sentence before you would be eligible for supervised release. So you're going to be out of commission for a while. That isn't necessarily going to help the victims of your financial fraud, since you owe a whole lot of restitution, but it ought to give peace of mind to Ms. Bragg, because you are going to be not in a position to be reaching out to her while you're in custody. So I will sentence you to a term of 2 years on count 1, and a term of 2 years on count 2. Those will be concurrent with each other, they'll be probated, but importantly, the sentence in this case will run consecutive to your federal case. We'll get that case number, and that will be baked into your sentence. So the 2 years of probation on this matter does not begin until you completed your federal sentence. It goes without saying that the primary special condition of your probation will be that you have no contact, direct or indirect, with Ms. Bragg. You don't call her, you don't write her, you don't try to get in touch with her through an intermediary. Reach out to her family or shared friends that she once had. If Ms. Bragg brings to the prosecution any evidence that you tried to contact her, I will be, upon proof, revoking all your probation. Just know that that's what will happen. I am banishing you from Georgia, with the exception of the Southern Judicial Circuit, which is way down in the swamps of South Georgia, right on the border with Florida. So you don't need to come to Georgia. You will be in Illinois, and if for some reason you are dying to set foot on the red clay of Georgia, it needs to be in the Southern Judicial Circuit and nowhere else in Georgia. You being physically present in any other part of Georgia would be the same kind of trigger as contacting Ms. Bragg would be a reason to revoke all of your probation. Mr. McMenamin, if you were here in the court, you would sign your indictment. I'm holding up, indicating your plea of guilty. You don't read it, it's your indictment. But you are not here. Do you authorize me to sign on your behalf? Your sentence hasn't started yet. You're not violating your sentence. If you escape from prison and go to Macon, you're not violating your sentence here. Your sentence doesn't start. Correct. So when you are released from federal custody, you move into this apartment in Chicago, then you need to be thinking about, I better not do this. But if the feds, if Bureau of Prisons shifts you through Georgia again and again and again, that's not violating this sentence because this sentence will not be done. Siri Patel, may I sign the indictment on your behalf? And Shama Patel. And Shama Patel, Siri Patel may have asked this, but do you weigh any issues arising from the fact that we are proceeding from a copy of the indictment rather than the original? All right. I think I've covered everything. Siri Patel, do you have anything else you need to cover? Shama Patel? Oh, okay. Mr. McMenamin, your sentence in this case, as I mentioned, will not begin until you completed your federal sentence. I suspect that will mean until you complete the portion of supervised release that you'll have as well, which is going to be a few years. I don't control that part, but it certainly will not begin until you are released from the Bureau of Prisons custody and move to Chicago. I think we've covered everything. Do you have any last questions? So I believe that's the case, but the person who will help you with that would be Shama Patel. If you are trying, the BOP is saying you go to a halfway house now, and then they say, oh, no, you can't because there's this state case. She'll let me know and we'll figure out the logistics. Because I'm giving you a probated sentence rather than a custodial sentence, it makes no sense to prevent you from getting to a halfway house and begin adjusting back to living in regular society. I don't think you'll run into that issue because you will have been sentenced, but if you do, we'll figure out how to fix it. All right, thank you everyone. Thank you, Ms. Beasley, for making this work across who knows how many strange phone lines to FCI home. All right, bye-bye. All right, we are ready for Mr. Mackis. Mr. Patel is going to pop out of the jury room. Ms. Hall is here. And then, ready for it. Can you get that on the screen?
I'll take it. Okay.
One second.
Your mom is watching the call right now. Just okay.
Patel, you're.
Yes, Your Honor.
Great. Ms. Rivers, can you hear us?
Yes, I can.
Great. Well, we're gonna get started with our final position. It's 18 SB 162-119, State versus Mathis. Hello, Mr. Mathis.
How you going?
All right, how are you doing?
All right.
Good. You're going to be answering a bunch of questions in just a little bit, Mr. Mathis. So you'll need to speak up a little bit. That
Okay.
microphone should pick things up. We'll make sure Ms. Rivers can hear you. It's my understanding, Mr. Patel, that Mr. Mathis is prepared to enter a plea in his case where he's charged with 2 counts of second degree burglary. Is that right?
Yes, Your Honor.
Mr. Mathis, in just a moment, Ms. Paul, the prosecutor, is going to put you under oath. Once you're under oath, it's important that you answer Ms. Paul's question in mind, truthfully and completely. It's just as important that you let me know or Ms. Patel know if you have any questions of your own. Because at the end of this, I need to have a finding that you understood everything we were talking about. There shouldn't be any surprises, but things can happen. So if something comes up that doesn't make sense or is different than what we were expecting, please let me or Ms. Patel know, okay?
All right.
Great. All right, Ms. Hall, when you're ready.
Thank you. Mr. Mathis, can you please?
Mr. Mathis, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. Please state your true, correct, and legal name.
Say it again?
Oh, can you state for the court your your name, your full name?
Oh, you want the Mathis?
Are you at this time under the influence of any alcohol, drugs, or medicine?
No,
Is there any medication that you normally take that you have not been given today?
no.
How old are you and how far have you gone in school?
I made it to the senior, no credits.
You're in high school,
Yes,
and how old are you?
26.
26?
And are you able to read, write, and understand the English language?
Yeah.
Do you understand that you've been charged with 2 counts of burglary in the second degree? Do you understand that you have the right to
I'm
plead?
sorry, I can't hear the defendant.
Okay, you got a belt in that.
Yes,
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
yes,
Do you need more time to discuss this case with your attorney?
no,
Are you satisfied with her services?
yes,
Counsel, do you waive formal reading of the indictment?
So wait,
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
wait for the purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
We wait.
Mr. Mathis, have you been arrested on these charges?
as in arrested, what do you mean?
Do you remember being arrested for the burglary charges that we're here for today?
We're just trying to make sure you're not aware of any warrants that are outstanding for you in connection with this case. Are you aware of any warrants?
No,
Thank you.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
a suspended sentence.
Okay. The minimum and maximum sentence for burglary in the second degree is 1 to 20 years to serve. You understand?
1 to 20 years.
Yes, that's possibly what you could get if you went to trial and you were convicted on these charges. A minimum of 1 year, maximum of 20 years. You understand?
Yes,
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for both counts, 5 years to serve 2, commuted to time served, balance on probation, special condition that upon completion of 1 month of probation, the balance be suspended, and that you stay in compliance with your sentence in Rockdale County. Do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each of these charges and can run those charges consecutively or one after another. Do you understand? Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
It can.
Yes.
I've been locked up. I'm already locked up. So like,
I'm just explaining to you that if you're on probation, that when you're on probation, if you commit another crime, that your probation can be revoked. It doesn't really apply in this case because these charges happen all on the same day. So I'm just reading. I just want to make sure you understand.
Yeah.
You understand?
Yeah, I understand.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Are you asking to be treated as a drug first offender under the provisions of the Drug First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, you're under first offender probation currently. So you would say, I've not been convicted of a felony, I'm under first offender.
Okay, I'm under first offender probation for Rockdale County.
Okay. Have you ever been sentenced for any crime, felony, or misdemeanor under the Drug First Offender Act?
No.
Has your lawyer explained the Drug First Offender Act to you?
Yes.
Excuse me. Do you understand that if you violate the terms of the Drug First Offender sentence or commit a new offense while on Drug First Offender probation, your Drug First Offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Well, she said a lot, so.
Do you understand all those rights that you're giving up?
Because we're taking the experience, you don't have those rights because you're not going to trial. So do you understand? Not going to trial, you don't have the rights that come with going to trial.
Yes, I understand. Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
In indictment 18 SC 162119, how do you plead to 2 counts of burglary in the second degree?
Suspended sentence.
So we'll talk about what your sentence is going to be. Before we get there, you need to tell me whether you're pleading guilty or not guilty. That question was, how are you pleading to the 2 counts of burglary?
I'm in a blind light right now. Like I'm trying to get like, do I got a guarantee?
So there are very few guarantees in life. There's no guarantee that I will agree with what sounds like the negotiated sentence that your lawyer has worked out with the prosecution. But what I can tell you is, if I sentence you more severely, let's say I give you 2 years in prison,
you'd have the ability to withdraw your plea and say, I'd rather go to trial. So if I go along with what they're asking for, you don't get to withdraw your plea. But if I sentence you to something more severe, then you can back out of this. So no, there's not a guarantee that you have the ability to walk away from this if the sentence that I decided is the right sentence. It's different from what I deserve. That makes sense?
I mean, that's basically what I'm trying to get to now. Can I get to a bond?
So bond isn't what we're here to talk about. Today, we're just working through, are you admitting that on August 28th, you broke into Sonic and Chevron gas station on Moreland? And if you did and you're pleading guilty, we're going to talk about what are the consequences. It sounds like the request that your lawyer is making is that I basically reduce your sentence, time you've been in, and then you go to probation. You're on probation for 1 month, and if that goes smoothly, then the rest of the sentence is suspended. But for us to get there, you need to answer Ms. Hall's question, which is, how are you pleading? If you plead not guilty, that's great. We'll stop what we're doing and we'll get to the trial sometime. If you plead guilty, then we'll move on talking about, well, what should the sentence be? Did I explain that well? Or
Yeah, you explained. Yep. Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 30 days from today, from the date of the sentence, to appeal this, to file an appeal, and that you only have 4 years from today for a felony charge, 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you. Your Honor, I'll start with the facts. On if this case had proceeded to trial, the state expect the evidence to show that on August the 28th, 2018, at 1401 Moreland Avenue, Southeast Atlanta, Georgia, that's in Fulton County, officers responded to that location in regards to a hearing a audible alarm system at that location going off. When they arrived, they observed the bottom half of the glass shattered to that business. They entered the gas station and they notified the owner. They did a follow-up. During the investigation, they learned that there was another burglary that happened down the street. When they were able to receive that surveillance of that burglary, they were able to tie the defendant to both burglaries. He was arrested in the same clothing that was worn on the video of the 1401 burglary. At the second burglary, the first burglary was at a Sonic's restaurant. The second burglary was at the gas station. They used the Sonic's surveillance to identify who the defendant was in the gas station burglary. In the gas, there were pennies on the ground, scattered on the ground at Sonic's. At the gas station, it was reported that over $500 was taken out of the safe. They saw in the surveillance video that the defendant dropped something in the grass when he left. They were able to retrieve a crowbar, the tools that he used to get inside the safe. It was inside of they was dropped in the grass. I believe that is all as far as the facts in these two burglaries. So he didn't have any convictions on this day when these incidents happened. On this same day, there was also a burglary in Rockdale County. He now has a conviction on that burglary. That is why we came up with pretty much for this sentence to run concurrent to that. He was arrested. He did do time for the Rockdale case, which was also a burglary. He has 7 years, 4 months, and 8 days remaining on that case. And I believe that is all from the state, Your Honor.
I need you to connect the dots a little bit more. So there's video footage from Sonic that is gathered in certain clothes. How does Mr. Mathis get connected with that? They just find walking down the street near the burglary?
No, I'm sorry. Sorry. He was arrested at the Sonic. So when they had him in custody, he was still wearing the exact same clothing from the video that they watched at the gas station. It was like a green shirt, a blue shirt and green shorts.
So Mr. Mathis did not get away from the scene of the crime and stop. Whatever he was trying to do there, he got caught.
He didn't get away from the scene of Rockdale's burglary. Right. I did. I'm sorry.
Was the third.
Yes.
That day.
Right.
He was caught in Rockdale, and there's somehow a collaboration between Rockdale Police and APD, and they realized, wait, this guy that we found in Rockdale with the second degree burglary matches the footage we got from Sonic or from Chevron or both.
Yes. Rockdale contacted our officers and told them they had him in custody, and that they kind of completed the investigation that way. There were several burglaries that went on. They only charged him with the 2 that they had the surveillance video for, but there were more that happened, I believe, on Moreland, but they didn't go into the investigation of those.
Any evidence that there's more than one person involved, or the video footage that it did get showed just blue shirt and short? Yeah.
It just showed the one male, green shirt, blue shorts, green shirt.
Got it. And Mr. Mathis in Rockdale, first offender, not drug first offender, but regular first offender.
Yes.
For the Rockdale.
Yes, Sean.
Understood. Ms. Crawford, do you have anything else for criminal history for Mr. Mathis, or just that open case with a little less than 7.5 years left?
The only case that he has is that Rockdale County case, nothing else active.
All right, thank you.
You're welcome.
Mr. Bell.
Thank you, Your Honor. What Ms. Hall stated is correct. It's very unfortunate. Before this, Mr. Mathis had never been arrested even for misdemeanor. He was working for his grandfather's HVAC company. He had his life together. He was doing well. His grandfather passed away, which meant that he ended up losing his job while also grieving the loss of his mentor. Essentially became transient, not quite with a home. He picked up using oxycodone and essentially lost his mind this day. He doesn't even have a recollection of the events. That's why he was confused by Ms. Hall's, were you arrested? He was technically arrested in Rockdale County. He doesn't remember what all he did that day. What we do know is that there is a DeKalb County hold for him now, which I suspect, given the area of Moreland, which is a divider for these two, that this is going to be another burglary. I tried to look into it myself, but nothing is on OJS yet since he has not been arraigned. Rockdale County gave him a 10-year to do 4 sentence. So he's been in continuous custody since 2018. He's currently on parole, and then he'll start the Rockdale County probation. When Ms. Hall and I were negotiating, ultimately, Rockdale County is a probation that if he violates, he will, he's not going to get the get out of jail free card. They could revoke him for the full. And so the threat of that hanging over his head, I believe, is enough to try to keep him on track. His mother is on this call, Tamika Mathis. I've talked to her quite a bit just about the circumstances, and she can attest to the fact that he was a good kid. He was doing the right things, and then this just came out of left field. He does have her support as well as his sister's support. He won't be able to live with his mother when he's released from DeKalb. However, they resolved that case because she is on, I believe she's on housing assistance, so she can't have anyone with a history reside with her, but he'll be living with his sister. I talked to my client in depth about whether he thinks he'd be able to stay sober, because right now we don't have any kind of a program lined up, and whether that's something he'll do through DeKalb County. He hasn't used since he was picked up because he has been in continuous custody. With that being said, he did make the most of his time in DOC. He took several classes. He took more recognition training. They had him in group and individual counseling while he was in prison. He said that the biggest thing he's concerned about is picking up smoking cigarettes again, which I said that I don't think that'll violate his probation as long as he stays away from everything else. And so we are, hoping that this is an opportunity for him to get his life back on track. He says he's got a couple HVAC connections that he's going to try to use as soon as he's released so that he can start working again. And so we're asking that Your Honor accept what Ms. Hall and I've worked out. And we recognize that ordinarily I would have sought some amount of oversight with his to make sure he doesn't relapse, but I just don't know what we'll expect with his DeKalb County case and the direction that will take.
So, Mr. Mathis can't stay with his mother. Where would home be?
I have that address. It is.
I don't need the street address. I just think this. It's not going to be really under our supervision. Be Rockdale. Is it in Rockdale County? Is it in Fulton County?
It's not. It's in College Park.
Okay. So it's in either Fulton or Clayton.
Correct.
Okay. What was the Rockdale County connection, if any? Why did Mr. Mathis end up there that day?
That I'm not sure about. Do you have any connection to Rockdale County, Mr. Mathis?
Yeah, I got a friend that's out there.
A friend?
Yes.
Okay. All right. The Rockdale County sentence, does it include any treatment, or it's just don't mess up or we'll drop the hammer?
I don't have a copy of the actual sentence. So I'm not sure. I could only take what Mr. Mathis told me, which is that they just wanted him to do classes in prison.
Okay. Ms. Crawford, did you have any visibility into what, if any, special conditions of probation came out of the Rockdale County case?
You're on mute.
You're on mute.
You said, do I have any of the, I didn't
The
hear you.
special conditions from the Rockdale County case.
Special conditions from the Rockdale case?
Yes.
Give me just a second. I can see if I have the sentence sheets, but we usually don't have their sentence sheets. Give me one.
Okay, well, if you can find it, that'd be great. Thanks. So, Mr. Mathis, you understand that your next stop is DeKalb County?
Yes.
Okay. And there's no restitution that you're seeking at this time, Ms. Hall?
No, Your Honor.
And Ms. Patel, the basis for a drug first offender on a non-drug offense is the background that you provided, that underlying his burglary was an addiction to opiates.
Correct.
Okay. Mr. Mathis, you were given first offender status in Rockdale. There's one other form of first offender status, and that's if the crime that occurred was in some way related to drug use, something like that. Is that a fair description of what was going on, that you were using prescription drugs at the time of these burglaries, which is why you don't remember a whole lot about what happened?
Yes.
Okay. You understand that a first offender sentence means that it will not show up as a conviction on your criminal history, which will help getting back to work if you want to go back to school, etc. But you'll still be under sentence until you complete your probation in Rockdale and you complete the suspended part of your sentence here in Fulton. You're under sentence. And if you get in trouble again because you're using drugs or something else, then you could be resentenced in this case, sort of like having your probation revoked. You understand that? Do you think you're going to be in a good position to stay out of trouble and out of the pills when you are released?
Yes.
Why is that?
I mean, going through the withdrawals, you know what I'm saying? So like, it's just I'm not trying to go back through, you know.
Okay. Well, understanding the benefit of first offender, no criminal history, and the risk of first offender, if you get in trouble again, you could be resentenced, which in this case means you could be sentenced up to 20 years, I guess 40 years if they ran consecutive. I don't think that's what would happen, but you have a lot of exposure if things don't go well while you're under sentence. Do you understand that? Understanding the risk and the benefit, do you want to be sentenced as a first offender?
As a drug first offender.
Oh, yes.
Okay. All right. Ms. Crawford, any success?
Yes, Judge. He had the usual conditions. The first one said that he should not change his place of abode, avoid persons with harmful intentions, report to probation. He's to make restitution as ordered by court, complete a residential or non-residential program. He has
Well, that's the magical one. That's good to know. So Rockdale is going to require Mr. Mathis to get some addiction treatment. That makes me more comfortable. I bet that'll make the cab more comfortable because I don't plan on putting any conditions in this case. It'll be the Rockdale case that will govern. Okay, well, Mr. Mathis, I find there's a factual basis for your plea, August 28th. You were on Moreland Avenue breaking into some shops and taking some things. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we talked about. And if you didn't, you said, hold on a minute, and you had Ms. Patel explain, and then you answered the question. Is that a fair statement? Any questions about anything so far?
No.
Okay. I also find that your plea is voluntary, which means no one's forcing you to enter this plea. You've decided it's the right way to go forward in your case here in Fulton County. Is that also correct? All right. Then I'm going to accept your plea. I will sentence you as a drug first offender. So this will not show up as a conviction on your criminal history. And I'm going to sentence you on both counts to a term of 7 years to serve 2.5 years. You will get credit from the day of your arrest, which was August 28, 2018, and I'll suspend the balance. So it's a little different than what we were talking about. One difference is you've already served 2.5 years, so you're done with the jail time. Another difference is I'm not giving you any probation. I'm just suspending the balance. You asked for a suspended sentence. You're getting a suspended sentence. It's a slightly longer suspended sentence than what we've been talking about, but I think that's appropriate in case you're going to not treat this first offender situation the way you ought to, which is being real serious about it, staying away from the pills and staying out of trouble. Rockdale has more time to work with, the 7+ years, but we'll have a little bit of time to work with if first offender doesn't work out for you. But it's a suspended sentence. You'll be on probation out of Rockdale. I don't know what DeKalb is going to do. That's where you'll go next, because once I sign your sentence, you're no longer in custody on this case. You've already done your 2.5 years. Do you understand that?
Yes.
All right. That sentence, as I said, is a little bit different. I don't know if you describe it as more severe or less severe or really about the same. I want to make sure you're okay with it. You want to talk with Ms. Patel about it at all? You feel like you understand it?
I understand.
You want to accept that sentence? Okay. That'll be the sentence. Your indictment is right here. There's actually a copy of the indictment. Normally, we'd pass this around and everyone would sign it. I'm not going to pass it around, assuming you'll authorize me, Mr. Mathis, to sign your name on the indictment indicating your guilty plea. Is that okay that I sign for you?
Yeah. I mean, yes.
Okay. Ms. Patel, may I sign for you?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Great. I'll do that. It's just so that we keep the records that you were here on this day and you entered a guilty plea. The main record our court reporter has been keeping as you've been answering all these questions. I think that is it. Ms. Hall, anything else in Mr. Mathis's case?
Nothing further from the state.
Ms. Patel?
Nothing further from the defense.
All right, Mr. Mathis, I hope this works out for you. You've been in custody for a while. Be good to get you out, be back with family, and try and walk the straight and narrow, okay?
Yes.
All right, good luck.
All right, thank you.
All right, I think, Ms. Nelson, that completes the calendar. Is that correct?
Yes, sir.
All right, thank you, everyone, for your help today. We'll see you next time.